Welcome to the English-speaking panel at IBRAC. This is a tour through Latin America in order to navigate our different merger control regimes and to try to figure out our common grounds, our differences, and how you can actually be able to clear a deal or at least navigate tough waters in all these countries. And let me present you the guides for this trip. We have Beatriz Hidalgo, who's a senior director at FerradaNehme in Chile. We have Viviana Blanco Barbosa, the chairwoman of the Comisión para Promover la Competencia from Costa Rica. We have Fabricio Cardim, partner at Mello Torres in Brazil. We have Gabriel Lozano, partner at Bruchú and Funes de Rioja in Argentina. And we have Renato Guerrieri, who's a senior associate at Guyana and Regules and Uruguay. And a special thanks to Diego Hernández from FerradaNehme, who's also a co-creator of this panel. So as to get started, we are going to do the entire trip of a merger control case that goes wrong in Latin America. So let's go through the different steps and see how we can deal with them. The very first issue is in some way related to the previous panel in this very same room. We're seeing an increase of mergers throughout Latin America. We're seeing that regulators are pushing, in some cases, the criteria for notification. They're pushing for transactions that may be below the threshold. They're trying to get even more active in the analysis of merger control cases. So the very first question that we should address is, are we really seeing more merger control cases? Is it because thresholds are not being updated? Is it because regulators are pushing new theories in order to file transactions? So I would start with Fabricio to give us the rundown on Brazil.
Thank you, Santiago. Thank you. I would like to start by thanking IBRAC and for you to have me here today. I must admit it is a little bit weird to talk in English to an audience in my home country, in my home city, with an audience of Brazilians, but I think it's the best way of doing that. So thank you again. And so I think just before we get specifically on the question, I think this is a very important panel in terms of the way we are today in Latin America and how the agencies have been working together in cooperation, but I think that also applies to private bar, and so we really see a development in the region over the past years, particularly I think in merger control. So I think it's a very good timing to discuss these topics, and we've been discussing also throughout the region. Recently, I had the pleasure to attend with Viviani in Costa Rica, the 19th already Central America Forum for Competition, organized by RECAC, which is their network of agencies in Central America. Next week, we're going to have the OECD Competition Forum for the agencies in the region in Paraguay. So Latin American agencies, Central American, Americas in general. So I think these four are very important moments, so we can make these reflections and see the synergies between the different agencies and the different regimes. I would also like to, this is a panel on merger control, so I would just say about this book that has been recently launched yesterday by IBRAC. I had the pleasure to write an article there, but many here as well. It's a very interesting book that goes deep in specific questions in mergers. So I think that also connects to the previous panel we were discussing. So this book is bringing different topics on effects of mergers in Brazil, revenues, the definition of economic group, different types of concentrations, transactions, and cross-border multi-jurisdictional cases. We're going to discuss a few of these topics that are in this book here today. So going to your question, Santiago, we do see an increase of mergers in Brazil that have been reported to CADE over the past years. This year, until June, we had already an increase of 20% of mergers notified to CADE in comparison to last year. So it's a big increase, 20%. So we expect until the end of the year, where we get now, most of the M&A cases being closed by the end of the year. So we do expect a peak and a high number of cases revealed by CADE this year. So that's a trend, but we've seen this year particularly a significant increase in terms of mergers. We have seen particularly in the energy sector and agribusiness in Brazil this year, a high number of cases being notified. Last year, real estate as well and retail. So these are usually the sectors that we see a lot of activity in Brazil, and that is being reflected at CADE as well. So then we go to discussion specifically on Article 9 of the Brazilian competition law that lists the types of cases, transactions that should be notified to CADE. So basically mergers, acquisitions of control, but also assets, associative agreements, consortium, joint ventures. And that is something that we've seen the discussion in Brazil at CADE, which types of cases are should be considered, which type of mergers should be considered as concentration X, subject to a mandatory filing to CADE. And we just heard last panel from the General Superintendent, Alexandre, that CADE is considering now reviewing some of these criteria and types of transactions to give more clarity to the public in general, which types of cases should be actually notified. So he mentioned specifically ongoing work at CADE to review resolution number 33, but also that CADE is now discussing how to tackle, to review cases involving the acquisition of assets. So I think that these are very important initiatives that will help us to navigate in more detail which types of cases we should really notify, because that it has an important impact, as I said, in the number of cases that are being reviewed. So if you consider the criteria, it's not only revenues that he also mentioned, if it's ongoing discussion if we should revisit the thresholds for turnover, but also the types of transactions. So I think it's also always important to review and to revisit this criteria to make sure in terms of policy that CADE is doing, if we have the right balance in terms of types and quantity of cases that are being reviewed by the antitrust authority in Brazil. So that's why also it's a good moment to have these discussions.
Perfect. So more cases and a review of the criteria. What about Chile?
Oh, thank you, Santiago, for having me in this panel. Well, in Chile, we have a mandatory merger control regime since 2017. The National Economic Prosecutor Office, known as the FNE, the authority in charge of merger review, and the Competition Court only steps in when the FNE decides to block a transaction and the parties appeal the decision. In Chile, we're seeing a different trend. Since the regime was introduced, we have seen almost 300 filings. The number have fluctuated. We had a peak in the second year with 55 cases, and then a steady decline down to 28 last year and only 13 cases so far this year, with the exception of a temporary spike, but the trend it's clear. We may assume there have been two major causes to this. The pandemic probably had a role in this, but also the change and the modification of the thresholds in 2019. Today, the parties' combined turnover must exceed approximately $100 million. And another requirement, a cumulative requirement, is that at least one of the parties individually must generate more than $18.5 million in Chile. So the intent of the reform in the thresholds to reduce the number of notifiable mergers and the declining trend suggests this objective was achieved, actually. Another relevant element is the pre-filing consultation tool we have in Chile that was enhanced in 2021. And this tool allows the party to obtain the F&E's view on whether a transaction is notifiable or not, whether it is actually a merger under the law, and whether the calculation of the threshold is being done correctly. So we can also think that this mechanism has likely deterred some unnecessary filings, and that's why we're seeing this trend in Chile.
Perfect. How about Argentina, Gabriel?
Thank you, Santiago. Well, in Argentina, I don't see an increase of merger control filings. I took some statistics from back in 2022. There were 48 cases, 2023, 68 cases, 2024, 58 cases, and currently there are 49 cases. So maybe that is because of the threshold in Argentina, which is updated on a yearly basis. Roughly, we are right now in $76 million US, and you know Argentina is not a smooth country, so the dollar sometimes is very high, and then the threshold is very low for us, unfortunately.
The roller coaster threshold.
Yeah.
Always fun.
You know what it is.
What about Costa Rica, Viviana?
Well, thank you, Santiago. Well, first of all, I would like to thank IBRAC for the kind invitation. It's a real pleasure for me to be here. And regarding Santiago's first question, I would like to say that we had in Costa Rica an important reform to the competition law in 2019. It was part of the access of the country to the OECD. And after this reform in the competition law, we have noticed an increase in the number of mergers reviewed by the National Competition Authority. Between 2019 and 2023, the number of mergers cases more than doubled, rising from 25 to 54, which is remarkable considering the size of our economy. We are a country of 5 million people. In 2024, for instance, most transactions originated in key sectors such as energy, telecommunications, technology, pharmaceuticals, tourism, and food. It's important to clarify regarding to the thresholds that the new law does not establish fixed absolute values for merger notification thresholds. Rather, it empowers the competition authority to determine specific values within the ranges set by law, and we can update these thresholds periodically. The reform also introduced a criterion of incidence in Costa Rica, what was mentioned actually in the last panel, the local nexus requirement. And this is a new issue for a merger to be subject to notification. Likewise, the law introduced a two-phase review procedure. We have an initial screening phase 1 to assess whether the transaction raises obvious risk to competition, and a second phase where the competition goes to a more in-depth economic analysis, but more mergers are clearing in phase 1. And finally, we don't have a threshold based on the value of the transaction. So there is a possibility that some mergers involving startups or high technology industries could fall outside the competition authorities review.
So we have two that increase, two that decrease.
Another increase, of course. Well, thank you, Santi. It's a privilege to be a speaker here again. IBRAC is surely the leading Latin American forum for competition law discussion. Now, sticking to the topic, in Uruguay, we've had full pre-merger control ever since 2020. Immediately, we witnessed a boom in enforcement with more than dozens of cases a year, which is quite something for such a small and emerging jurisdiction. And also considering that the authority, unfortunately, lacks experience, lacks human resources and sufficient budgeting to manage all these cases, which tends to be a problem in the region. Initially, we had one single turnover threshold, meaning that if one of the parties met it, even at group level, any insignificant transaction could get caught, leading to quite a chaotic scenario, which was good business only for us competition lawyers. Fortunately, ever since, a few relevant reforms have been introduced. First, a second turnover threshold has been introduced to reduce the parties and transactions subject to control. Then an alternative, easier, speedier, etc. proceedings and filing form appear for scenarios in which this new threshold is not met. Another alternative filing form, not proceedings, appear for cases where there are no market overlaps and or for small transactions in terms of value of the assets involved. And lastly, and perhaps more interestingly, and similar to what occurred here in Brazil, there have been a few public consultations, one in particular in relation to the real estate sector after reducing and restricting merger control there after an initial and quite controversial decision according to which appeared that every acquisition of land or property would be subject to merger control. That has changed, fortunately, but there's still many unanswered questions and voids, and apparently new guidelines are coming up, more comprehensive ones.
Okay, great. We have seen some of those real estate nightmares in Argentina in the past. So let's move on to the second stage. We have already decided that we need to notify. So now we have carried out our filing. What should we expect? Not in terms of the competition agency, but rather from other regulators that may want to, one, intervene in the merger control proceeding, sometimes through regulations or sometimes just by pushing their way in, or in some cases of some regulators that may have some sort of competition ancillary powers granted to them by their very own regulation. So, Viviana, you want to take the lead on this?
Yes, thank you. Well, in our case, it is important to know that we have two competition authorities. We have a COPROCOM, that is the National Competition Authority. We are in charge of promoting competition in all sectors of the economy except for telecommunications. And on the other hand, we have SUTEL, which is the regulator in the telecommunications sector and also holds competition powers within this sector. With that in mind, I will refer to the coordination between the competition authority and the sectoral regulators, specifically in the telecommunication and financial sectors. In the first case, with SUTEL, we have a model where SUTEL needs to formally request COPROCOM's opinion. The law states that COPROCOM's criteria are not binding. However, if SUTEL decides to depart from them, the resolution should be duly justified, and the approval needs a qualified majority. This creates an institutional dialogue in which competition concerns remain visible in the final decisions. In practice, in most cases, SUTEL has followed the recommendations of COPROCOM. We usually maintain a good coordination with them. Actually, we publish joint guidelines and carry out activities, advocacy activities together. However, when it comes to case analysis, reaching consensus can sometimes be difficult. We have two recent examples where both authorities reached different conclusions. The first case, it was a case in the national wholesale fixed broadband market, where the National Competition Authority considered that the evidence in the file was not sufficient to rule out competition risk and therefore recommended blocking the merger. And another case involving paid television, distribution of sport content, television advertising, and bundled fixed services. As in this case, the Commission also refrained from issuing recommendations to the regulator telecommunications authority because we consider that the information available in this file was not sufficient to rule out competition concerns, particularly in multi-sided markets. And I think this later case reflects the complexity of having multiple institutions analyzing the same matter in the context of digital markets or multi-sided platforms. because some of them may have powers limited to specific markets individually. So the kind of information that you need is not necessarily complete for each authority, and of course, one market has an impact on the other. No, these two cases are currently under appeal, so I cannot go into details. And in the other model that we have with the financial sector, the procedure is a bit different. In this case, the parties involved in the merger, they go directly to COPROCOM, and we have 3 days to inform the financial regulator. And in this case, the financial regulator, which is CONACYF, if they identified systemic risk, its prudential review overrides the competition analysis. So although this mechanism was introduced in the 2019 reform to strengthen antitrust review in financial mergers, in practice, prudential considerations have prevailed over competition concerns. For example, over the past 2 years, all the mergers originated in the financial sector have been handled exclusively by CONACYF without the COPROCOM's opinion. And we cannot issue an opinion simply because we don't have the time. They immediately take the case, and we cannot do requires of information to the agencies, to the agents. I think these 2 examples highlight the need for clearer rules of engagement between regulators to ensure legal certainty, not only to the economic agents, but also to the authorities, to safeguard the role of competition analysis in regulated markets.
All right, so a lot of regulator activity in Costa Rica. What about Argentina, Gabriel?
Well, thank you. Within 3 days as from the filing, when a regulator is involved, the Antitrust Commission will request them to issue a report stating if they are okay with the transaction or not. They have 15 days to issue its report, and in case of silence, it is assumed by the law that they are not object the transaction. In case of the central bank, when the transaction involves banks, that is a prior request. So I think it's the only one, no?
And certain telecoms.
Telcos, sometimes.
Depending which telecom.
Yeah, exactly. So there, sometimes it is quite interesting to see what the regulator has to say, but at least in my experience, they are not issuing a lot of reports, and they just let the term lapse.
Okay, so a lot of activity, almost no activity. Renato, once again, you decide.
Another angle, which is a negative experience in those interactions, at least from the private practice perspective. And you're right, there's a welling tendency towards centralizing enforcement in the antitrust authority. We have legislation clarifying that only the telecom regulator, central bank, and the water and energy regulator have antitrust faculties, and that these ones are restricted to merger control because the antitrust authority is the sole enforcer of anti-competitive practices. However, there are multiple challenges in relation to regulator. Regulators tend to be understaffed, unexperienced in terms of antitrust enforcement and expertise, and have their own timeline. They also have the possibility of consulting the authority before deciding, but they do not necessarily do so. And in any case, the authorities' say is not binding for them. The regulators also tend to pursue objectives and subject their review to standards which are not necessarily aligned with the competition review, and in some cases ends up being contradictory, like strengthening of a national champion. And lastly, what we see more is that there are multiple cases of dispute over jurisdiction between the authority and the regulators, usually negative ones, where each of them pass one case to the other, creating uncertainty, wasting time, and stopping the clock. So unfortunately, that's the scenario.
Good to know. Fabricio, what about here?
Right. So, well, in Brazil, we have a very traditional regime of like regulatory agencies dealing also with competition matters at the same time as CADE does. So usually the way it works is like through cooperation agreements between the agencies, where CADE, of course, has the final decision on mergers, on cases, conduct cases, but the regulatory agency is invited to, in the specific sector, to provide opinions, studies, market studies to complement the analysis, right? I think one very important example we had in Brazil that took decades was like the intersection, the financial services and the authority from the Central Bank of Brazil and CADE. There was during the 90s and early 2000s a long dispute that went to courts on who would be the authority with the jurisdiction on financial services and cases. And recently, this dispute was solved by, it went all the way up to the Supreme Court, and now you can see like a true cooperation between the two agencies when there is a systemic risk involved. I think similar to what Viviane said in Costa Rica, the central bank can take the lead. When there is no systemic risk, CADE is the final authority to decide. So I think that's a very interesting example when you see like the development of the financial services in Brazil and how after of these years of disputes, both agencies managed to agree with each other, and now they work very closely together. And you can see already the results on that and how the financial services in Brazil have been developing very fast over the past 10 years. And I think that is also part of the result of a good coordination work that the agencies did. And just a final remark on this topic. We are talking, of course, about regulatory agencies, but I think nowadays we also see this in the previous panel, how the merger cases are becoming more and more challenging worldwide, and you start seeing different stakeholders taking place in the review of mergers too. So we have different FDI regimes in different jurisdictions, but even not formally with new laws, but also some type of politics playing around in different agencies, maybe not even from the same country, but all the other countries asking information about that merger and that merger in a specific jurisdiction. So I think that is also a trend we will be seeing in this new polarized world, and how the different agencies, regulatory agencies, not only in the country but outside as well, can play with each other.
When nationality becomes a factor for clearance or not, right? So regulators, a lot of activity, no activity, not that much activity. They send the ball to each other so as to avoid working. Regulators that have learned how to work together. Chile?
Well, in Chile, competition authority coordinate with the regulator. They will always require their input when deciding a merger, but the FNE has been very clear. Merger control is conducted strictly on the basis of technical antitrust analysis. So broader policy or public interest, geopolitical, national security, foreign investment concerns are not taken into consideration. Although they require their opinion, the FNE will only solve on antitrust analysis. We have a few sector-specific cases where the opinion of the competition authority is legally required. Even there are no thresholds involved. We have the national television law that requires a favorable report from the FNE before certain transfer of broadcasting rights can be authorized. And we have a very interesting case that is not properly a merger, I would say, but the extended producer responsibility law requires that the competition court must review the governance structure of the recycling entities, since that the law requires to be formed, since they typically bring together competitors with the competition risk that this entails. And this decision of the authority to decide only on antitrust consideration is set in the Chilean Competition Act, right? Well, where it states that the sole purpose of the law is to promote and defend competition. And therefore, merger control only will be solved with following the legal standard, which is that the transaction may substantially lessen competition. This approach has been consistent in the case law. A case that involved electricity distribution, in that case, the FNE made explicitly that the issue of national security or strategic interest were irrelevant to solving the case. Even though there was some opposed parties that tried to bring the case that there were foreign investors involved in such a key utility as distribution of electricity. We have another case in the lithium market where the FNE emphasized again that unlike other jurisdictions, Chilean law does not provide for public interest review in merger cases. So, in short, I would say that Chilean authority coordinate with the regulator, but in the end, merger control is characterized as a strict technical competition-focused standard without taking into consideration any specific sector's concerns.
The way it should ideally be, right? So we filed the transaction. We have been able to dodge other regulators that want to mess with our deal. The commission is reviewing our case, but it's taking too long. We are lawyers. Our client gets anxious. He wants, you know what? And go ahead anyway. I want to close the deal. I can't wait more for these guys. What's your advice, Beatriz?
Well, on this topic, I would say that in Chile, gun jumping has become an increasingly significant part of the FNE's merger control agenda. Under the Chilean law, gun jumping is treated as a per se infringement of competition law. This means that the FNE does not need to prove adverse competitive effects in the market for liability to be established, even if the merger is ultimately clear and even if it's clear with no remedies. Just implementing the transaction before authorization, it's an infringement. The requirements are very simple. First, the existence of a concentration operation as defined in the law. The transaction must meet the thresholds. The transaction was not notified and it was perfected without clearance. We have a gun jumping case. Once a merger is filed before the FNE, the implementation is automatically suspended until authorization. That's why we have these cases, right? And during this period, any step toward implementing the transaction will be deemed unlawful. To detect infringements, what the FNE does is monitors the market, the public information, and disclosures made to the Financial Market Commission that the companies are forced to do when they are taking these major decisions, right? In the recent years, enforcement has intensified. In 2024 alone, we had 5 investigations into potential gun jumping cases. From the whole 13 cases we have had since the regime entered into force, 2 of them ended in court. 2 of them were settled. The 2 of them were settled. A very interesting case is one that started right when the regime started. It's a Minerva JBS case that even though the deal was ultimately approved without remedies, the FNE brought the case before the court, alleging that the parties closed a transaction abroad before having the clearance in Chile. The 3 main arguments from the authority were the first one, that the acquired influenced the administration of the target in Chile by deciding some commercial aspects of the functioning of the Chilean target, like export volumes and pricing. The second reason was that the acquirer had access to strategic and sensitive information. This is a main issue for authority. If you have access to that kind of information, you will probably will be found liable. And the third one was that in a response to a client complaint, the Chilean target instructed the customers to address directly to the acquirer. So the case was pretty simple for the authority. The parties argued that they had a carve-out agreement designed to shield Chile from the influence of the acquirer, but the FNE deemed that ineffective. The case settled at the end with the payment of $1 million. So it's an important thing to have into consideration. But what is interesting is that we have had relevant cases, and what is important is that while more of the cases are dismissed, the FNE, when examines the case, not only search for the thresholds compliance, but also make a substantive analysis in all the cases. So it's very interesting. We have one case in the ice cream market where the FNE remarked that the parties were so close to the thresholds that they should have opted for a voluntary filing. So it's really on these things. We have a few ongoing, very interesting cases. One on the ski resort market, where the acquirer became the owner of 2 of the 3 ski resorts in Santiago. So the FNE decided to open an investigation only based on public information disclosed to the market. We have a case where an investment fund acquired a private clinic, and the FNE suspect thresholds may have been exceeded and the control transferred prematurely. And another case in the shopping center market, where what's interesting about this case that although the parties had initially disclosed that the deal would be subject to the FNE approval, the transaction was closed without undergoing the mandatory prior review. So we don't know what is going to happen now. But in short, and to end this right, gun jumping in Chile is sanctioned as a strict liability offense. It's enough that the transaction was implemented before clearance, even if the merger raises no competition concerns. And FNE has made this a clear enforcement priority, and companies must take a special care not only in determining whether a sanction is notifiable, where the results are surpassed, but they must comply with the suspension of the transaction. And I would say that a good advice would be to go to a pre-filing or approach the authority, because they will initiate an investigation if they have a suspicious.
So you have already scared the client by saying $1 million in gun jumping fines.
Exactly.
Renato, can you scare them more?
No. Unlike Chile, in Uruguay, there are no relevant precedents yet in relation to gun jumping, other than some generic legal and regulatory provisions prohibiting it. However, in practice, we've had some interesting active discussions, especially after the skyrocket penalties in the US and Europe in Canon, Altis, Illumina, Verdum, etc., and other cases recently. And ever since, parties to, let's say, more sophisticated and multi-J transactions have been more careful than before, especially during the standstill period. Usually seeking the best practices, or at least we as competition councils try to convince them to resort to them. These practices, this is nothing new for most of you, include naturally notifying timely, but otherwise, in our experience, reaching out to the authority proactively and transparently as to explain the rationale behind the decision not to file. And mostly during the standstill period, we have the typical clean team agreement, electronic firewalls, non-disclosure agreement, trying to, in general terms, restrict the information exchange, its use, and the parties to whom it is disclosed to, and of course, naturally not prematurely integrating activities or assets, but still parties to mostly domestic transactions still assume significant risk and minimize gun jumping, knowing that there are no significant precedents so far. And lastly, and super quickly, another more premature discussion now in my country is the consequences of gun jumping infringement, because initially it was said that, okay, will only affect the effects of the transaction and could lead to penalties, but there are some voices now talking about potential effects to the validity of transactions, which is quite significant. That's
Okay,
it.
That's tough. Talking about tough, Viviana, you're the one that actually imposes the fine. So what's your view?
Well, Under Costa Rican competition law, late notification or failure to notify is handled through a special administrative sanctioning procedure different to the merger control procedure. And the law establishes that the early implementation constitutes a very serious infringement. The fine could be even 10% of the turnover of the firm in Costa Rica or the economic group. Also, the acts carry out in violation of these provisions may be declared null. No, we have two recent cases. In the last 5 years of gun jumping. One of them occurred in the pharmaceutical sector in 2022 when Coprocom sanctioned COFASA. COFASA is one of the most important pharmaceutical groups in the country. And they failed to notify a series of mergers carried out during a period of 6 years. Then we have another example in 2020 in the market of radio advertising. In this case, La Nación, which is the biggest newspaper company in the country, and that also had business in the radio sector, sold all his participation in the company, no, and it was not notified, and the transaction exceeded the legal threshold. In these two cases, they are all now totally finished in the administrative sphere and in the tribunals. In those cases, Coprocom imposed monetary sanctions, but the sanctions were not too high because it was prior to the competition reform law of 2019. Actually, after the reform, we have not imposed new sanctions. So I think that maybe the new fines are effective to reduce the incentives of the agents to do this kind of practices, no?
Perfect. Gabriel, you wanna explain the upside down reality in Argentina?
Okay. As you know, we are still a post-closing merger control review, so we do not have gun jumping. Although what we do have is late filing fees. So since 2019, when we have the new law enacted, up to 2024, we have 21 cases for late filing fees, no cases in 2025. As you may know, if the Antitrust Commission detects some transaction, they will initiate a preliminary investigation in order to confirm whether the transaction was subject or not to the mandatory notification. They will call the parties to the transaction to explain why the transaction was not filed, and at the end they will impose sanctions if they believe that the transaction should have been notified. Something that is quite interesting, as you may know, is that the statute of limitations in Argentina is 5 years for the antitrust law. And there is a ruling from the Court of Appeals in the city of Buenos Aires, Civil and Commercial Federal Court of Appeals, that said in a very debated, very complex,
For lack of a better word.
yeah, exactly, that there are no statute of limitations when you do not file a transaction. So it's quite interesting, and the fines are on a daily basis. So the more time you do not file the transaction, the more fines you will pay. So be careful.
So you could end up in a situation in which even a hardcore cartel would actually have a fine that would be lower than a late filing fine.
Exactly.
Because a hardcore cartel actually has a statute of limitations.
Yeah.
And this one does not. Thank you, judges.
Argentina.
Thank you very much, judges. Fabricio, we left the worst fines for the very end, so scare us.
Well, I thought we had high fines in Brazil, but I see 10% of the turnover in Costa Rica and daily fines in Argentina. This is scary. Well, in Brazil, we have like in the law a range of fines for gun jumping that goes from 60,000 Brazilian reais up to 60 million Brazilian reais. It's around $15 million, the maximum. And we had cases already. So CADE is very active in enforcing this piece of the legislation. We had one case, there was international merger involving IBM and Red Hat, where the parties tried to carve out the deal from Brazil, and they had a fine of 57 million Brazilian reais as penalties. So CADE set up in that precedent that, you carve out agreements do not work in Brazil. So be careful with that. We also had more recently in 2022 the imposition of the highest fines, so the up to the maximum under the law, 60 million Brazilian reais in a case involving FUSØES and Veolia. So this is this is the really bedrock of the pre-merger regime control in Brazil, and CADE has been very active. We have like since 2019 around 40 cases fined by CADE due to gun jumping. In an average on these cases, we could see like a fine around 6.5 million Brazilian reais. So it is something you need to be cautious here. And we can see more and more frequently in M&A cases, like the parties taking efforts since the inception of the transaction to implement like clean team rules and governance in order to avoid gun jumping fines.
Perfect. The kind of things that maybe 10, 15 years ago in all our jurisdictions, clients were fighting against. What is the clean team? Why should I do this, right? They needed the scary story so as to understand that. So we move on to the next level. We have already filed. We have avoided other regulators. We have actually convinced our clients to calm down and to wait it out. Now we get to a stage in which the proceedings are quite well advanced, and we get a statement of objections and maybe some interim measures. How do you deal with that, Gabriel?
Very interesting ways. Well, in Argentina since 2018, we have 9 statements of objections issued by the antitrust authority. 5 of them included preliminary injunctions. One of them, which I will explain later, it's a case in which the transaction was cleared. Afterwards, our president publicly stated that the transaction was not to be approved by the Antitrust Commission, and then the Antitrust Commission issued a preliminary injunction stating that the companies must hold separate businesses or administrations for at least 6 months. They should not share confidential information, as you mentioned in Chile. And it's quite interesting because that is the Telefónica and Telecom case, and they appeal such a preliminary injunction, and the Court of Appeals, again in the city of Buenos Aires, civil and commercial federal courts, overruled the decision by the Antitrust Commission. So the parties are free to move forward with the transaction. And there's a specific request from the Court of Appeals stating to the antitrust authority that you cannot issue any other relevant ruling that may prevent the parties or prevent the effects of that transaction to occur, which is quite
very odd.
Very odd, yeah, and very rapidly they issue that ruling. The statement of objections in the other cases involves several industries. TV pay sports, for example, ingredients in the food industry, cell phones, what else? Cosmetics, liquid oxygen also.
And a peanut-based.
Yes, and Hergali. Yes.
The mantecol, a very Argentinian thing.
Yeah. and it's quite interesting to see as from what combined market share the Antitrust Commission will issue a statement of objections, at least in Argentina, as from 40% combined market share, that will, put the transaction on the spot within the Antitrust Commission.
Right. How about on the other side of the Cordillera?
Well, in Chile, we have had, I would say, few cases on this, but with very strict consequences. In Chile, when the FNE detects an infringement of the merger control regime, it must bring the case to the competition court. It's not the FNE that decides, and the infringements include, failure to submit, materialize the transaction while suspended, not complying the remedies, materialize the transaction against the authority blocking it, of course, submitting false information, and the delay of submitting the filing carries a daily fine up to $17,000 per day. So it's significant. Interesting cases, I would say one, it's a case in the ferries company at the south of Chile, in which the transaction didn't surpass the thresholds. However, the FNE filed a claim against the parties and against the transaction for acquiring, because the acquirer acquired its only competitor and therefore became a monopoly in the relevant market. So it wasn't mandatory to notify, to file the transaction, but the FNE deemed it anti-competitive on the substantive analysis. The parties settle. You can see that it's usual to settle this kind of cases, and the parties commit to some behavioral measures related to the pricing system and some limits into the contractual terms of the agreements between the ferries and the providers, right? We have another interesting case, the Disney case, where the transaction was approved, and the FNE filed a complaint against the party for submitting false or incomplete information. One of the parties settled, paying $237,000. The party that didn't settle was sanctioned with $2.5 million.
Difference.
So very different. And that decision was actually upheld afterwards by the Supreme Court. In another case of convenience store markets, the transaction was approved, and the FNE filed a claim for, again, false information, submitting false information, and failure to comply with the remedies. The parties reached, again, a partial settlement only regarding the remedies, but the allegation on submitting false information continues. So this case is confirmed. There are a few cases, but confirms that in Chile, strict compliance with the merger control regime is non-negotiable, from timely filing to full accuracy of the compliance with the remedies. So beware.
Perfect. And Fabricio, you do not have statement of objections, but you do have interim measures, right?
Yeah, so the way it works here in Brazil is a little bit different. So if one case is challenged by the general superintendents, there is an opinion that goes to the tribunal, not necessarily with the proposed remedies yet, but the challenges of the case. So it's a little bit different, the process. But I would like to take this question to address specifically injunctions in mergers, because it's something there is still room to do it. You asked in the previous question, okay, if the parties are involved in a merger and they need to expedite a deal, what they can do. Sometimes there are things you can do. So there was this very interesting case I worked in a couple of years ago where we filed CADE a request for MSC, the liner shipping company, to exercise certain political rights and vetoes until CADE made its final approval. So MSC was acquiring a public traded company in Brazil, Login, which is a true corporation in the sense that there was no controlling shareholder. And there was a risk at the time that MSC acquired the company in the stock exchange market. The directors could leave the company, so there will be no one there. So in order to protect the investment, we filed a request to CADE requesting basically like an interim measure where we could, MSC could exercise certain political rights and vetoes, even though we didn't have the approval from CADE, the final approval on the merger itself. There was a specific regime in the law that the regulation that allowed that, but it was never tested. So we were able to create with CADE this precedent, which is, I think, is a good example to be creative also in mergers and find ways sometimes, through interim injunctions or interim measures where you can already do something even you don't have the final approval from CADE. Of course, this is very exceptional and limited to certain cases, but there is room there for that under the legislation too.
Great. Renato, do you have statement of objections? Do you have injunctions?
We don't have injunctions. We don't have formally statement of objections, but there are some relevant comments relating to statement of objections and challenge. Of course, it's always challenge the thing during the proceeding. Even though there's no statement of objections nor state of play meetings or equivalent like in Europe and the US, etc. There are 4 key moments in which the authority issues some sort of decision, sometimes intermediate decision, naturally formally declaring the filing correct and complete, then passing potentially to phase 2 review when a case could lead to a negative competitive effects, potentially, and this is perhaps the strange thing, reporting the parties and notifying them of a final decision draft 2 weeks in advance of the final decision and granting them the so-called in Spanish vista previa, which is in a way a written closing remarks before a hardcore decision. And lastly, issuing the final decision on the merits. Even though not explicitly envisaged, I believe that the statement of objections should arise when you pass a transaction to phase 2 is the moment where the theory of harm should start appearing. However, in practice, we witness that the authority tends to pass multiple cases to phase 2 more lightly with a low threshold of potential effects rather than the serious doubts under European law, and many times just to gain time. But even when it does it for a more justified reason of being complex cases, there's no theory of harm at that stage, but it's the decisions which are more generic in terms of, oh, we need further review. What happens is then that the true statement of objections de facto arises too late in the proceedings with this vista previa, and the parties are not given sufficient time as to structure and propose remedies or alternatives.
Okay. And Viviana?
Thank you. Yes, in Costa Rica, the statement of objections arises in phase 2 of economic analysis when the authority sets out its concerns and gives the parties the opportunity to present defenses or propose remedies. The statement of objections includes, as in other jurisdictions, of course, the definition of the relevant markets, the assessments of substantial market power in those markets, the analysis of unilateral and coordinated effects, the assessments of efficiencies, if it is applicable, and the identification of anti-competitive risk in the markets affected by the transaction. Later, the parties may offer commitments to the Commission. The Commission can evaluate these commitments and say if they are sufficient or not. We can propose our own commitments, and the parties can pronounce about them and say if they agree or not to adopt them. We also have oral hearings with the parties if they ask for this possibility, and we also have interim measures in the law that we have the possibility to establish this kind of measures, but until now we have not applied them in merger cases. In recent years, we have had several transactions in sectors such as cement, rice, private universities, where we have established conditions to clear the transaction, and only one merger that we have blocked in the airline sector. But yes, the statement of objection is basically established in this phase of the analysis, and the parties have the possibility to interact with the competition authority.
Okay, perfect. So for the last hour, we have notified the transaction, we have avoided other regulators, we have actually convinced our client not to do any gun jumping, we have gotten a statement of objections, and we have spent very long nights answering it. And now comes the final decision. You get a call from the regulator saying, we want remedies, or we are going for an outright blockage. You have to call your client. When you call your client to give them such great news, the first thing they're going to ask is, are there actually remedies being placed in your country? Is it true that they can outright block the transaction? And what does Renato say?
I'm coming from a difficult experience, so I must say yes. We're facing a context where even the smallest and jurisdiction in Latin America are facing more strict merger control. We have seen that this cannot be easily bypassed anymore with low risk, and Uruguay is not the exception. The authority has the authority, or is entitled to potentially block a transaction or to subject it to any sort of remedies as in any other civilized jurisdictions. Most cases end up being authorized and clear in relatively speedy and harmless phase one decisions. Yet we've seen several cases which have been reviewed more thoroughly on phase two. Is it during this stage that the negotiation of remedies appears? In many cases, most in Uruguay, most of these remedies are softcore, let's say behavioral ones, the typical we all know, like price and capacity related commitments and requests for information, so the easy ones. However, we have a few landmark cases already of structural remedies or like of divestitures where that had been unsuccessfully negotiated, leading to transactions being controversially blocked, mostly on the grounds of unilateral effects and specifically strengthening dominant positions. In a really high-profile case in 2024, in which we participated at the firm, so it's difficult to be objective, the key argument for the rejection was that the divestment was proposed too late in the proceedings. And this reveals the structural problem that I mentioned in my previous topic, which is that other than some hints, when passing the case to phase two, you don't have a true theory of harm until the vista previa. And without that level of competitive assessment in advance in the proceedings, the parties may reasonably have no appetite to assume risk or to offer more painful remedies. To fix these issues, there's a bill currently discussed in Parliament, in the Congress, to extend the standstill period, which again is a problem itself also, but it gives room for more negotiations. And in another related high-profile case just decided, in which we also participated, there was a double divestiture proposed, and in spite of that double divestiture, the transaction got blocked again on the following arguments. First, that one of the assets, it was a fixed first. The potential and proposed buyer was considered not to have sufficient local experience in spite of being a well-respected group with global presence. And ironically, if presented as a standalone buyer instead of a remedies package, it would benefit from the first landing exception, merely bypassing merger control altogether. And in relation to the other asset involved, which was a fix-it after, it was said that the time for the consent agreement was too lengthy, which it's a reasonable concern, yet the timeline appeared in day one with the filing form, and only 8 months later, this concern was first arise by the commission. On the other hand, we've noticed a handful of cases initially blocked by final decision by the authority despite negotiation of remedies, but afterwards, and magically after administrative remedies or appeals, there was a reassessment of the case, of the market definition, of the participation of the parties more favorably, leading to follow-up revocation of their own decision and authorization. This may seem like happy endings, but administrative remedies, at least in Uruguay, are too time-consuming, too uncertain. Doesn't sound natural to win this case in that way. And if unsuccessful, you could only have litigation, which takes years, and no long stop date would end so long. And super quickly, we've seen other type of cases where after favorable authorization decisions have been issued and closing took place, then opposing parties, mostly competitors, filed their own administrative remedies against the decision, creating further uncertainty, and until the final decision is confirmed with a res judicata with a definite effect. So that's the changing and challenging scenario in my country.
So lots of, it's a bit of a moving target.
Yeah.
How about you, Fabricio? What's the deal in Brazil?
Yeah, so I think in Brazil we already have a very traditional analysis over remedies. CADES has guidelines for, negotiating and imposing remedies. So I think this is very consistent already over the pre-merger notification regime. I just comment here, I think, two trends that I can see like in negotiating remedies with CADE recently. So you can see over the past years like a mix of behavioral and structural remedies being posed or negotiated by CADE. I think in the beginning it was more like behavioral, and now it's turning a mix of both. And then you have to be, and usually the way it is negotiated, it's very focused on the deal, on the business, very specific. So it's a case-by-case approach and analysis on each sector, each market involved, and that can take a lot of time and efforts to negotiate these remedies. Another trend, I think it's worth mentioning, you can also see in a few cases, I would say not remedies, but commitments that the parties might be willing to offer CADE in order to avoid a more complex discussion on the market. So that usually happens when the case is still at the general superintendents, and you can see these usually behavioral commitments in between lines of the decision from the general superintendents, which is good in one way because it facilitates to solve a deal that could be challenged after and been more problematic. So it's a way of getting solved. So it's good on that sense. On the other hand, I think is also something we need to be a little bit cautious about that in terms of accountability and transparent, because not always these commitments are clear in the decision. So sometimes, and then the case wouldn't go to the tribunal, right? Because if there is a remedy, the case needs to be reviewed by the tribunal. So, but I do see this as a trend, which is good, but we also need to be cautious not using this when a remedy is really necessary on a specific case.
Great. Now we move on to the person who accepts the remedies or blocks the transaction. Viviana?
Yes, it's very interesting to be in that role. Well, we have the ability to impose structural or behavioral remedies. The remedies, of course, are binding, and failure to comply may result in severe sanctions, including the revocation of the approval. The remedies applied have been in Costa Rica have been mainly behavioral. It includes compliance programs, periodic reporting of prices and other statistics and indicators, the hiring of external audits, functional separation of companies, among others. I have two specific examples where we accept the mergers, the conditions and approve the merger, and one in which we reject the remedies proposed by the parties. In the first two cases where we accept these remedies, one case was in the rice market. We request to implement a compliance program, but focus on preventing the exchange of strategic information with competitors, because this market is prone to collusion. And they also offer to implement this program not only within the company, but also through the production chain. So they will implement the program between producers, processors, and distributors of the rice. They also include the appointment of a compliance officer. In the cement market, which is also prone to collusion, the merger was authorized subject to conditions. They have also the request of the compliance program, but also they hire external auditors to report to COPROCOM on non-discriminatory practices, and also the submission of annual reports on prices, clients, discounts, margins, this for a period of 5 years. In the case that we blocked the merger, this was a merger between JetBlue and Spirit. It was in the airline sector. We have two roads that were highly concentrated between La Florida and Costa Rica. And in this case, the parties offers remedies that consist on report the strategic information. They said fares, sales, passenger statistics for 5 years. They offer to maintain the same fare setting methodology, to provide the staff training, and not to eliminate roads between La Florida and San Jose for 7 years. But in this case, we consider that the conditions or the remedies proposed by the parties were not enough to offset the competition concerns. So we reject the merger, and then the merger was rejected in the US as well.
Great. Now we have 3 minutes so as for Chile and Argentina to give us the bad news. What are your horror stories? Yeah, please.
Well, not all horror stories. In Chile, most of the mergers are clear unconditionally. 250 out of the 300 have been clear with no remedies. But when remedies are imposed, the FNE, like many agencies worldwide, prefers structural remedies because they don't require permanent monitoring. However, recent practice has relied more on behavioral commitments, especially related to address information exchange risk. For our authority, information exchange risk is one of their priorities, and one of the more things that concern them the most. So I would like to address this. We have the most recent cases. The FNE requires a lot of commitments regarding governance, protocols to prohibit or forbid data flow between competitors. Even they have imposed like interlocking restrictions that goes beyond the law, and extend the prohibitions not only to directors but also employees and consultants. So one of the obsessions of our authority is exchange of information. And we have had only 4 blockages. 2 of them were brought to the competition authority, trying to reverse them. The first one in the food industry was a success. It was reverted by the competition court with remedies. The second one is very interesting. It's a case involving private health insurers where the FNE blocked the transaction. The parties appeal. The competition court blocked the transaction, upheld the FNE decision, and the parties try a very unusual path. They submit a disciplinary action against the ministers of the court to bring the case before the Supreme Court. And the Supreme Court accept the disciplinary action and reverse the decision, which is a very different and unusual way to decide on merger.
Perfect. Gabriel?
Are we going to explode?
We're about to explode.
Yeah, it's in red.
I don't know where we're going to explode, because of the clock or because of Rivas staring at us.
Okay. So in Argentina, most of the transactions were approved without condition. That means that roughly 95% of all transactions were approved. 4% of all transactions were conditioned to some behavioral or structural remedies, and less than 1% of all transactions were blocked, depending on how you interpret if they were blocked or not, okay? But at least there were 7 transactions that were blocked in the last 20, more or less, years.
And the clock says exactly 000, so we delivered it on time. We did it. Thank you very much, and see you afterwards at the dinner. Right?
Yeah.